Good morning, Your Honor. Jeff Hulet on behalf of Hogan Hewlett.
Morning.
Good morning, Your Honor. Brenoch Wirthlin on behalf of the full color parties.
David Mahon, trustee of Full Color Games Incorporated. All right, it's on calendar on motion to withdraw.
Yes, Your Honor. Yes,
Okay.
as you may recall, Your Honor, we were brought in, my firm was brought in as conflicts counsel for Full Color Games, Inc., because there were some derivative claims in the case that required separate representation from Hutchison and Steffen. And those matters settled, and the time has come now for us to withdraw as counsel. Hutchison and Steffen has indicated they will step in and represent Full Color Games, Inc. upon our withdrawal, so it won't interrupt the case, any ongoing matters, and any appeals that may follow. And, I don't want to get into the details, but from our perspective, we're not willing to continue representation. And I know that Mr. Mahon has been frustrated with some of the rulings in the case, some of the outcomes, and he has issues with representation from both law firms. I understand that, but under the authorities we cite,
I called this case out of order because there was no written opposition. Is there an opposition to this motion?
There is.
Okay, I'll have to call it again. Okay. I'll call it in due course. Okay. Thank you.
Thank you.
The appearances have been stated. You want them to be restated? Okay. All right. So it's a motion to withdraw. And now, Mr. Mahon,
Yes, sir.
go ahead with your opposition.
There is no opposition filed. It's just a verbal opposition. Unfortunately, counsel for Full Color Games Incorporated has not communicated with its client, Full Color Games Incorporated, since approximately July of last year. The motion that was filed was quite the surprise. There was no communication, no meet and confer saying we wish to withdraw. There was no statement whatsoever. It was just showed up. Then what shocked us even more is that it was filed on OST. So whether
It was filed on OST, but it was then continued.
well, actually,
Right.
yes, sir. And then, unfortunately, the other primary partners of the company had emergency knee replacement, so they were unable to be communicated with because they were on doctor-ordered medication. So I was able to speak with them on Sunday. So we have not had an opportunity to even obtain legal counsel to address Mr. Hewlett and deal with the potential withdrawal. As Mr. Hewlett aptly stated, there are many concerns. If you recall, Your Honor, I've been in your courtroom approximately 65, 70 times. I've had the unique distinction, or you said this was arguably one of the longest complaints you've ever seen filed in the history of your court. So you're no stranger to the complexity of this case. Just to hire other counsel, it's quite a process, just clearing conflicts to get someone to come in. There is so we just need proper time to get counsel, the corporation. I, as a trustee, I was also the CEO and the director of the company before it was dissolved. Now statutorily the trustee once it was dissolved. I have a duty to the shareholders to make sure that their interests are represented properly. So that's just my fiduciary duty that I'm attempting to maintain, Your Honor. So we oppose it, whether we fully oppose it or not. We just need to at blush to oppose it so that we can get counsel so that I maintain my fiduciary duty to the shareholders to act in their best interests, if that makes sense to you, Your Honor.
Well, the question I have here, this motion is made by counsel to withdraw as counsel for Full Color Games, Inc.
That's correct.
Right?
Yes.
Now, you're personally involved in this case as well, right?
It's represented by Hutchinson and Steffen, and I believe Brenoch Wirthlin is who represents me individually, and Intellectual Property Holdings, Jackpot Productions, and the litany of the other parties. They still represent all this. So if you recall, your order separated Full Color Games, Inc. was suing Full Color Games, Inc. because of the derivative shareholder status of the case. And MGA, which represented the plaintiffs at the time, motioned the court to disqualify Hutchins Stephenson because I was individually represented at the time. You ruled in their favor against our opposition at the time, and that's what caused the separation, to force all the parties at the time that were represented just by Hutchins Stepp to then have two separate counsels. So from that point forward, through all these appeals, whether it went to the Nevada Supreme Court or whether it stayed here, has always had two completely separate counsels by your court order.
When you talk about the need to have time to engage counsel, what further proceedings are there in this case?
Well, you have a motion for summary adjudication, I believe, docketed in August right now. That's from some other parties that did not file a motion to dismiss. There is some confusion in the case on your order. I've been asked not to speak about it or talk about it by Hutchinson and Steffen, so I need to respect their request on that. If they wish to talk about it, they're here if you wish to get their opinion on that. But
I remember
my fiduciary duty to the shareholders.
when this motion originally came before me. What was it, last week?
It was 2 weeks ago.
2 weeks ago.
Yeah,
We
two-
asked for
2
a
weeks ago.
continuance because
Counsel
Mr.
from-
Howard had
Right.
knee replacement surgery and he couldn't be.
Right,
He's
counsel
not
from-
even allowed to fly.
Counsel for Hutchison, counsel from Hutchison and Steffen were present at that time, right?
They were present in person, and Mr. Hulet was via Blue Jeans.
Is anybody from Hutchison and Steffen appearing today?
Yes, I am here, Your Honor.
Okay,
And I believe and I appreciate Mr. Mahon's comments. I understood what he was doing, that he wants to put that on the record. We did, as Mr. Hulet mentioned, we are happy to substitute in on behalf of Full Color Games, Inc. What Mr. Mahon's referring to in answer to Your Honor's questions about further proceedings, there was a motion for summary judgment filed by other parties. We think it's moot because the order dismisses all claims, but we're working that out with the other parties that have filed that. But yeah, as Mr. Hulet mentioned, I think Mr. Mahon mentioned, we are willing to substitute in on behalf of Full Color Games, Inc. With the court's consent, because as Mr. Hulet mentioned, I think Mr. Mahon mentioned as well, those conflicts that had existed previously, we believe have been resolved.
you want to respond to that?
Difficult position to be in, Your Honor. Respectfully to Hutchison Steffen, who's my other counsel, as me individually, and the LLCs that I'm the sole member of, completely concur. In the shoes of Full Color Games Incorporated, the shareholders have opposition to Mr. Hulet's withdrawal for matters that I've been respectfully requested not to discuss here until the corporation is represented by counsel, simply because I'm sure you're aware there's appeal going up and all kinds of other matters. And in the shoes of intellectual property holdings and Jackpot and me individually, the court is aware that there was a second case filed,
Right.
but the court is not most likely aware of the fact that there's only one or two claims that are being moved forward. That's not the whole case, because statute of limitations ran on many of those claims. So it hurt all parties really badly when the case was dismissed here, because it injures them, and the other parties that still remain in the case, which would be Richard Newman in law, Cooper Blackstone, Brian Marcus, they didn't ever appear and oppose your the motion to they didn't try and get the case dismissed under the 5-year rule, as did the Spin and the Bragg parties. So there are unknown issues here, and it just requires some proper due diligence with other counsel for Full Color Games Incorporated, it would be remiss of me not to go get that counsel. And it'd be, so I.
So I'm
need more-
understanding you say you don't accept the notion of Hutchison and Stephan now stepping
I
in?
do if legal counsel that needs to be representing the corporation advises me, the trustee, that that would be in the best interest, because remember, I individually and my corporations were sued under one of the most unique forms of lawsuits possible, where somebody hijacked my corporation and sued me as a derivative shareholder. So I am under threat of being sued by the shareholders again under a derivative shareholder lawsuit if I don't continue to act in their best interests. And that's all I'm respectfully asking the court to do is either A, give me more time to get counsel, because once again, it's very complicated to clear all the conflicts, because you've seen the docket, you've seen the list of how many attorneys have appeared before the court. So, Your Honor.
You're in the process of seeking to do that?
Yes.
Okay. There's a motion for summary judgment scheduled for August 8th. And what is that motion?
I'll let Brenoch speak to that.
Certainly, Your Honor. That's the motion we were referencing that other parties have filed. Again, our position, we believe, is that it's moot because of the dismissal, but we're addressing that with the parties that have filed that motion.
And Mr. Mahon is involved in that motion? I'm sorry, Full Color Games is involved in that motion?
I believe it is as to certain claims. I'm not sure, as I sit here today, Your Honor, whether that's directly involving Full Color Games, Inc., but I can certainly address that with opposing counsel.
I can speak to it, Your Honor, that it is true. Full Color Games Incorporated is involved in that. There's Full Color Games Incorporated, there's Full Color Games North America Incorporated, there's Full Color Games Group. So yes, it's still intermingled.
All right, Mr. Hulet?
Couple of things. First of all, I spent 2 full days in deposition with Mr. Mahon at the end of October. So to say I haven't communicated with him since July is factually incorrect. And there's been subsequent emails that I've had. We are not required under the rules to remain hostage in a case where it's financially untenable and philosophically untenable to remain in. Now, the motion for summary judgment that's being discussed, that was filed after we filed our motion to withdraw. And we graciously gave 2 weeks extension on this motion. I'm coming to you from vacation because it was represented to me that we could work something out. Mr. Prell said, yeah, we're likely to get it worked out and get a substitution. I'm just trying to be courteous, but we can't remain in entirety. There's always motions in this case. And Hutchison and Stephan is handling the opposition to the motion for summary judgment. And I believe also Hutchison and Stephan represents Full Color Games, Inc. in the second lawsuit, if I'm correct. So there's no reason for our firm to remain in. There'll be adequate representation for Full Color Games, Inc. And we've been long suffering, and we really believe under the rules and the authorities we've cited, we were able to get out now.
How much time do you think it's going to take, Mr. Mahon,
Can I
to?
respond to that, Your Honor?
Yes?
And then answer your question second. May I do that, Your Honor? To respond to that, there are issues that the shareholders have with Hogan and Hulet for allowing the case to be dismissed. They believe that there's liability on Hogan and Hulet's part for failing to get the case to court. This was discovered when we went into mediation with Honorable Elizabeth Gonzalez, who was our mediator, who was a former business court attorney and or judge, Your Honor. So there's more than meets the eye here of the complexities here, and that's why it's so quintessential that we have the adequate time to get proper counsel.
That's what my question is. What is adequate time?
It's at the discretion of the court. I'm working as fast as I can. I've been already working at it, as you know, for 2 weeks solid, and it's going to take a minimum of 2 to 3 more weeks, I believe, because if you recall, there, I believe, have been like 14 different law firms that have already appeared in this case, and it's even though Las Vegas is a large town, it's a very small town, with all the conflicted out law firms that are qualified to handle the matters moving forward. So it's created quite a challenge for me to find counsel that's not conflicted out.
Okay.
Because, and let me add one more piece to that, if I may. There may be counsel that says they don't want Hutch and Steffen to be representing the company moving forward. I don't know. I just owe the duty to the shareholders and to everyone, no matter what shoes I wear, to at least get advice of counsel.
Okay, Mr. Hulet, last word, it's your motion.
Under the authorities we've cited that were not opposed, other than this argument today, we are able to withdraw today. There will not be any delays in the case hearings that's the analysis you have to determine. And you can hear already, his issue is already saying words like negligence, and we can't remain in when that relationship is broken. It's not fair to him, it's not fair to us, and that's what the rules contemplate. So we're asking for our withdrawal today, please.
All right, here's what I'm going to do. I can't continue this next week. What I'll do is continue the hearing on this motion. I'll do a special session on Tuesday, August 6th at 9 a.m. All right, because my calendar on Monday, the 5th is very heavy. I'll schedule it for Tuesday, August 6th at 9 a.m. for further proceedings on this motion. And I'll expect you, Mr. Mahon, to use your best efforts to promptly seek replacement counsel, and to consider also the contention or the prospect of Hutchison and Steffen substituting in for full color games.
Respectfully doing that, Your Honor.
Okay.
Just once again, maintaining my fiduciary duties to cover
Understand.
everybody's.
Okay. So that's it.
And Mr. Brenoch, did you, is he okay with that as well, or does?
Well, I've made that
Thank you.
ruling and going to continue it to the 6th at 9 a.m. Special session, right here on this motion.
Thank you, Your Honor.
Thank you.